As Mr. Young said, my name is Floyd Falcon. I'm the attorney for the Troopers Association. I wanted to start off by telling you it's my belief that the Louisiana Constitution provides in two separate articles dealing with classified employees very clearly that no rule shall favor or discriminate against an employee because of his membership or non-membership in a private organization. The initial rule was part of the Constitution in 1973 when it was adopted as Rule 10, Section 10. When the Constitution was amended to provide for the State Police Commission, that provision was carried forward and exists in Article 10, Section 48. We believe it is very clear. And we believe that the proposed amendments as written are going to discriminate against employees because of their membership in a public organization or private organization. I want to give you a little bit of the history. I don't mean to bore you. I appreciate you all intelligent people. I appreciate Mr. Simeon has a great deal of experience in the law, and each of you have some experience. But I want to just make some comments, and I appreciate if you would just bear with me. One of the initial cases dealing with the subject matter encompassing these rules was the Canatella case in 1992, decided by the Fourth Circuit, and an application with writs was made to the Louisiana Supreme Court, and the Supreme Court denied writs, which indicates that they approved of the decision. The Canatella case stands for the proposition that the prohibition against political activity does not extend to the labor organization. Labor organizations are distinct and distinguishable from its members. I've written the brief and I've quoted from the case law, but these are my highlights that I want to emphasize. But I ask you to look at my memorandum and read at least the excerpts in the cases that I've cited. The Canatella case goes on to stand for the proposition that an endorsement by a labor organization is not a personal endorsement of a member. Therefore, when the labor organization would endorse somebody, it's not a personal endorsement by a member. What your rule tries to do is make it a personal endorsement by a member. We believe that, for the reasons I'm going to relate to you as this proceeds, that is totally improper. Mention was made of the Kenner case, and I think Mr. Simeon mentioned where the Kenner case. The Kenner case was decided on a different set of facts than it presented here. It had to do with how a labor organization, in that case, the Kenner police, came to make an endorsement. But I think the most interesting case is the 2017 recent case by the Third Circuit Court of Appeals in Lake Charles, the Lake Charles police officers versus Randy Roach, who's a good friend of mine, who was the mayor for many years over there. Randy was not a champion of labor organizations by any sensitive word, but he was the mayor. He was the mayor of Lake Charles. But the Lake Charles case, the Third Circuit said that the prohibition against endorsing political candidates does not apply to a union or to a labor organization. Y'all want to make it apply to the union or to the labor organization by killing that labor organization because its members can't be members and be classified civil servants. That's what your rule says. your proposed rule says. The Lake Charles case, interesting. If you just read the newspapers and don't read law books, you probably heard of the Citizens United case that was decided several years ago by the United States Supreme Court. The Lake Charles decision adopted or made reference to Citizens United, which was the United States Supreme Court case. It stands for the proposition that unions and corporations are entitled to the First Amendment protection of freedom of expression. In other words, a labor organization can express freely its opinions. The Citizens United case, interestingly, specifically said that nonprofits are persons entitled to the protection of the First Amendment of the United States Constitution. The LSTA is a nonprofit corporation. It is entitled to freedom of expression. In Davis versus Henry in 1996, the Louisiana Supreme Court said, any doubt regarding public employees' rights to organize was removed with the adoption of Article 10, Section 10 of the Constitution. That's the provision that I alluded to earlier that says no rule that the commission cannot pass a rule that either favors or discriminates an employee because of membership or non-membership. The Davis decision further acknowledged the right for employees, not just in the private sector, but also in the public sector, to organize, to form an organization, and to advocate for its members. There's a couple of Attorney General's opinions that I've cited for you. In the Attorney General's opinion, it says the endorsement of a candidate by a labor organization is not proscribed by any law. Well, y'all want to make a law, or in this case a rule, that would proscribe against that. I don't think you can do that. The Attorney General's permission say that an endorsement by a labor an endorsement by a labor organization is not a personal endorsement of the members, but rather an endorsement by the organization. And that statements made in meetings of a private organization are private. They don't have any, they're not violative of the right, the prohibition against political activity. Let's talk about the association, the right to be in an association, a private organization. In Buckley versus Vallejo, the United States Supreme Court in 1976 says, the First Amendment protects political associations as well as political expression. The First Amendment is not just freedom of speech, it's freedom of association. The Supreme Court in 1979 in Smith versus Arkansas highway employees said it's clear the First Amendment protects employees' rights to advocate ideas, to associate with others, and to petition the government for redress. It protects the right of an association to engage in advocacy on behalf of its members. That's what the Louisiana State Troopers Association does. It advocates on behalf of its members. Its members have a right to belong to such an association. These amendments are going to crucify that right and destroy the association. The Fifth Circuit U.S. Fifth Circuit, the circuit that governs Louisiana, Texas, Mississippi, this area, and provides us with insight into the federal law, says, in Bodie versus the City of Columbus in 1993, said, the right to join a union or a labor association is protected by the First Amendment. That's the federal court for this area. The Seventh Circuit, in a later case, actually in a prior case, it was of the same opinion. The right to join an association is protected by the First Amendment, freedom of association. You cannot govern who your employees associate with, except in rare circumstances, I guess, if they're associated with, and I'm not even sure this, the Communist Party or somebody like that, but they certainly have a right to participate in labor organizations of their choosing. The 2017 cases that came out of federal district courts in Texas that recently cite Bodie and stand for the same proposition, the right to freedom of association. I cite those cases because those cases are governed by the law as announced by the Fifth Circuit Court of Appeals, which is the Court of Appeals that governs this area. One of the interesting cases that I found that I think is most applicable to this situation was a federal district case in Western District of Louisiana, the northern part of Louisiana, Lawson versus the City of Monroe. First Amendment protects public employees' rights to associate with labor organizations, recognizes the right of a union to engage in, and this case talked about a union, but the same is true if a labor organization is not a union, recognizes the right of a union to engage in advocacy and petition the government on behalf of its members. So when we have a registered lobbyist who goes to the legislature and talks to legislators about wages, hours, working conditions, conditions of employment for its members, just like the Sheriff's Association does, they have the right to do that. And it's been repetitively approved and announced by the courts, both state and federal. I wanted to give you a little bit more insight insofar as the state police policies and procedures and the state police code of conduct specifically recognize the right of members of its classified employees to be members of private organizations, but more specifically says the Louisiana State Troopers Association and also the Central States Coalition. The Louisiana, the State Civil Service Commission puts out circulars about political activity. I didn't know this. I've learned this since over the last 2 years. But apparently, in speaking with the people over there, they do this recurrently whenever there's a big political cycle or it's election time in the state government. They put out circulars. And their circulars addressing this issue say they acknowledge the right of classified employees to be a member of an organization that endorses political candidates. That's what y'all trying to deny us. So long as, this is a quote from their circular, the primary purpose of the organization is not the support or opposition of candidates, parties, or factions. You have the right to make an endorsement on behalf of an organization, as long as that's not the sole purpose of the organization. I was tearing up listening to these ladies' comments the primary purpose of the Louisiana State Troopers Association is far from making endorsements. They rarely do it, but they've done it. They have a right to do it. You can't take that right away from them, of the organization. You have no jurisdiction over the organization. I want to conclude by saying that your Section 10, 48.3, again, I'm repeating myself, but it says, no rule shall favor or discriminate against any employee because of his membership or non-membership in a private organization. 2 years ago, the Louisiana State Troopers Association made political endorsements. You pass this rule as written, then no person or any person who remains a member or who remains on the board of this organization is subject to investigation and disciplinary action and termination by this commission because they belong to an organization now that made an endorsement in the past. Well, I tell you, they can make endorsements. They can associate with whom they can have freedom of association under the First Amendment. But irrespective of all of that, the Louisiana Constitution guarantees them that freedom of association, the right to be a member. I remember, I'll say something on a personal basis, in 1971, 72, I was either still in law school or I was just holding the briefcase, just got out of law school and holding the briefcase of a man that was a member of the Louisiana Constitutional Convention that ultimately became constitutional. And he told me, and I'd expressed to him an interest in being involved in representation of organizations and employees in the public sector, not the private sector. On 2 occasions he told me to come with him to the Constitutional Convention meetings that particular day. The first day was when the Constitutional Convention was considering what became Article 10, Section 8, because before 1973, the employee, now think about how wrong this is, the employee had the burden of proof to prove that they were right in any appeal and that the employer's charges against them was wrong. Fortunately, the framers of the 1973 Constitution made it clear that the employer, not the employee, has the right. The second time Jack Evans told me, you need to come and listen to these arguments today, was when they considered Article 10, what became Article 10. It didn't even have, I guess it didn't have a number then. Article 10, Section 10, which we believe is the answer to this whole issue, and prohibits you from making any rule, or which prohibited the State Civil Service Commission at the time, but 48 now is the same thing, prohibits you from making any rule that favors or discriminates against people who have a membership in a private organization. What happens if you pass this rule, proposed rule, to all of the 1,000 classified employees that are members of the State Troopers Association? We fire them all. We discipline all. We embarrass them all. I don't think the courts are going to prove that. I would plead with you to study the law before you make a decision to do something that we think is unconstitutional and illegal. Thank you.